Choose any ATM of your convenience and stand a chance to win gold sovereigns.
Lanka.
The writ petition filed by IGP Deshabandu seeking an interim injunction to suspend the order issued by the Mathura Magistrates Court for his arrest was taken up for consideration today before a Court of Appeal judge bench comprising Acting President of the Court of Appeal Justice Mohammed Tahir Lafar and Justice Sarath Disanayake. At the outset of the hearing, President's Counsel Romesh De Silva, representing Deshabandu, argued that the order issued by the Mathura Magistrates Court for his client's arrest did not adhere to correct legal procedure. He further contended that the report on which the magistrate's order was based does not qualify as a proper legal document under Section 136(1)(b) of the Code of Criminal Procedure. Therefore, he asserted that the entire order issued by the magistrate was contrary to law. Additionally, the counsellor for IGP Tennakoon stated that although the incident was under investigation while the IGP was actively on duty, he was not summoned to court to provide a statement regarding the matter. Based on these legal arguments, he requested the court to issue an interim injunction suspending the arrest warrant issued by the Mathura Magistrates Court. During the hearing, the bench of justices questioned the President's Counsel on why the IGP could not appear before court and provide a statement as a mark of respect to the Magistrates Court. In response, the President's Counsel stated that while IGP Tennakoon was willing to do so, there was a risk of him being arrested and remanded. He added that if an undertaking was given ensuring that his client would not be arrested, Tennakoon would fully cooperate with the investigation. However, Additional Solicitor General Dilip Piris, representing the Attorney General, stated that such an undertaking could not be provided. Upon further questioning by the bench of justices regarding whether the counsellor representing the IGP was aware of his client's whereabouts and where the affidavit related to the case had been signed, no clear response was given. Subsequently, Additional Solicitor General Dilip Piris, representing the respondents, argued before the court that Tennakoon's arrest was not a decision made by the police but rather a court order. Further explaining the incident in question, the Additional Solicitor General stated that during the events in Mathura, a group of 7 officers from the Colombo Crime Division had travelled to Mathura on the orders of the petitioner Deshabandu. Upon inquiry, the officers had claimed that they were conducting a raid to arrest suspects in a drug-related investigation and that the exchange of gunfire occurred as a counter-attack after a suspect fired at them. However, officers from the Waligama Police Mobile Operation Unit had suspected them to be criminals and opened fire. The counsel for the respondents questioned why officers acting under the direct orders of the then acting IGP Tennakoon fled the scene during the confrontation with the police. He further inquired why the injured police officers had not received even basic medical treatment until their vehicle was intercepted at a roadblock in Imaduwa. Additionally, he pointed out that the officers fleeing the scene had turned off their mobile phones throughout the operation and questioned the necessity of such an action if the operation was legitimate. The Additional Solicitor General further alleged that a criminal gang had been operating under the instructions of then acting IGP Deshabandu. He also stated that the Mathura magistrate had noted the need for an investigation into the actions of the then Minister of Public Security Tiran Alas. Accordingly, Additional Solicitor General Dilip Piris requested the court to dismiss the petition at the first instance, asserting that Deshabandu had concealed facts and presented information in a manner that did not comply with the regulations of the Court of Appeal. After considering the arguments presented, the Court of Appeal bench announced that it would deliver its decision on the petition on the 17th of March.